a cost-effective final resolution of their dispute. That is, my lord, one overarching consideration, my lord, which would weigh with us as we seek to
It all argued by Mr. Dattar
yes.
as well as Mr. Kambata also.
Yes. I was, my lord, adding one aspect to it also, my lord, which is that an arbitration agreement is also a decision actively taken by the parties that their dispute will be decided by arbitrators. It is, my lord, in that sense, opting out of a civil court and leaving the matter to an arbitral tribunal. These are, my lord, in my respectful submission, the tensions that weigh when your lordship will decide the guardrails of this modification. That is to say, my lord, the guardrails may not extend, and that's what I'll try and, my lord, develop, to the point where, my lord, the court is making a decision which the parties had otherwise felt the arbitral tribunal ought to make. My lord, once an arbitral tribunal delivers an award, then, my lord, it becomes functus officio, except for the powers contained in section 33. That is, my lord, the powers to correct clerical errors, and also, my lord, when an arbitral tribunal has not determined certain issues.
But if the matter is remitted under subsection 4 of section 34.
I'm sorry, my lord?
The matter is
yes.
remitted.
I was coming to that.
Under
yes.
subsection 4.
Yes, it is, my lord. The rule is, my lord, it is functus officio except for section 33 and the power under 34(4). Those are, my lord, the two. But otherwise, my lord, as a normal rule, the moment the tribunal delivers its award, my lord, it becomes functus officio. And, my lord, a party will have recourse to section 34 in respect of that award. My lord, I've tried to make this point at paragraph 2. The term recourse used in 34(1) is wide and includes the power to modify, vary, or set aside a part or a whole of the award. This is what, my lord, has already been argued. My lord, Iyer defines recourse as being the act of seeking help or advice, method of enforcement of a right. This goes, my lord, to what the court was putting across, my lord, that it is really enabling the arbitral award rather than finding ways to set it aside. The, my lord, recourse is a wider term and would include within it the power also to modify or vary. That is, my lord, the argument already made that the larger power encompasses the smaller power. And then, my lord, the other point, my lord, which is already made, but I'll just repeat it, my lord, there's no prohibition in the Act on the power to modify, and no such power can be read in by recourse to section 5.
That is also argued by Mr.
Yes.
But I said, unlike the Singapore Act.
Yes.
There's
an express prohibition. Here, my lord, there's no express prohibition. And in fact, my lord, what my lord Justice Vishwanathan was also putting, section 5 reads in material part, my lord, no judicial authority shall intervene except where so provided in this part. So actually, my lord, it is a gateway for the court rather than an obstacle for the court. To the extent, my lord, section 34 is read as a wider power of recourse, it is actually provided for in this part that a section 34 court can, in its exercise of a recourse to the award, modify the award. That is, my lord, the last limb of section 5. My lord, in paragraph 3, I make the point which your lordships have already, my lord, heard from Mr. Kambata and Mr. Dattar. Ultimately, the object of the Act is to provide an expeditious remedy. And the last 3 lines of paragraph 3 of my submission, my lord. If courts exercise the power to modify the award, it will eliminate the formality of going back to a new tribunal to reaffirm a conclusion which has already been reached by the court, thereby ensuring an earlier quietus to the dispute. This, my lord, forms the basis of, my lord, the guardrails that I would be submitting for your lordship's kind consideration. My lord, the point has already been made that in section 34, it is only 34(2)(a)(4) that expressly contemplated partial setting aside, to the extent that the award is severable to that extent. But your lordships have read that power to encompass all of 34, not limited to 34(2)(a)(4). That is, the judgment in JG Engineers and the recent Delhi High Court decision in Trichy, Tanjavur. But in addition to what has been submitted on that point, your lordship may note, my lord, in the Delhi High Court decision, there is a reference to the earlier versions of the model law that specifically contained a power to partially set aside an award. Those earlier versions did not find place in the final model law. Notwithstanding that, your lordships have found that where an award is severable and it does not impact other aspects of the award, that part of the award may be set aside. Even though, my lord, the earlier versions of the model law had a specific clause, which clause was not contained in the final. That's, my lord, only additional submission. And the reason your lordships have done that is, my lord, again, to make the Arbitration Act workable, to ensure expeditious dispute resolution, and to say that where a award consists of severable disputes, then to the extent of that severance, a part of the award can be set aside. And your lordships have gone one step further, my lord. Your lordships have said it should not even be only textual divisibility, but even substantial severability is okay. Because normally, my lord, the rule of severance was, or severability was, can your lordships draw one line through the offending part of the line, a part of the clause or the award. Your lordships have said we're not looking at it as textual divisibility, but substantial severability. Because, my lord, the argument I think that has found favor with your lordships is parties have subjected themselves to arbitration. An arbitral tribunal has correctly decided claims 1 to 5, but claim 6 is liable to be set aside on some head or some ground. That can be severed only to that extent the award can be set aside. And in that sense, my lord, I adopt Mr. Kambata's submission that partial modification, partial setting aside is also modification. Ultimately, your lordships are reading section 34 and saying, although it talks of setting aside an award, your lordships are saying an award is an agglomeration of various claims. And one part of that award, to the extent it can be severed, can be set aside. My lord, paragraph 5, I make the point which your lordships have already seen, my lord, that even in Hakim, where your lordships found there is no power to modify the award, the modification was upheld, only showing, my lord, that this is perhaps a need for the arbitration ecosystem. My lord, if I may just place one or two paragraphs of the judgment in Hakim. But if I may place only one or two paragraphs in Hakim, my lord, this is in the common compilation, page 11. Mr. Dattar's compilation. The very first compilation.
Written on it. The compilation is written.
So the judgment starts at page 11.
Yes, please.
Do my lords have it, my lord? Page 11. My lord, the judgment in Hakim initially, my lord, proceeded on the basis that earlier judgments of this court had already held that there was no power to modify. And in that regard, my lordship may have paragraph 25 at page 27. Paragraph 25. As a matter of fact, the point raised in these appeals stands concluded in McDermott International versus Byrne Standard, where this court held, and your lordship may come directly to paragraph 52 on the next page of McDermott. The 1996 Act makes provision for the supervisory role of courts for the review of arbitral award only to ensure fairness. Intervention of this court is envisaged in a few circumstances only, like in case of fraud or bias by the arbitrators, violation of natural justice, etc. The court cannot correct errors of the arbitrator. It can only quash the award, leaving the parties free to begin the arbitration again if it is desired. So the scheme of the provision aims at keeping the supervisory role of the court at minimum, and this can be justified as parties to the agreement make a conscious decision to exclude the court's jurisdiction by opting for arbitration as they prefer the expediency and finality offered by it. So, this observation in McDermott, where really the issue of modification did not arise, was the starting point of the analysis in Hakim as to why the courts cannot modify an award. And then, the lordships, also referred to Kinari Malik, which again, was a case under 34.4 and didn't squarely raise this issue. After finding, my lord, at paragraph 41, I'm sorry, at paragraph 42 at page 38, paragraph 42 at page 38. Is my lord the Chief Justice have it?
Yes.
Para 40. It can therefore be said that this question has now been settled finally by at least 3 decisions of this court. Even otherwise, to state that the judicial trend appears to favor an interpretation that would read into 34 a power to modify, revise, or vary the award would be to ignore the previous law contained in the 40 Act, as also to ignore the fact that the 1996 Act was enacted based on the Uncitral Model Law on International Commercial Arbitration 1985, which, as has been pointed out in Redfern and Hunter in International Arbitration, makes it clear that given the limited judicial interference on extremely limited grounds, not dealing with the merits of the award, the limited remedy under Section 34 is coterminous with the limited right, namely either to set aside an award or remand the matter under the circumstances mentioned in 34 of the Arbitration Act. Similar, the court proceeded on the basis, my lord, that there is a limited right conferred in Section 34. And it is that limited right that leads to a limited remedy. A different articulation, my lord, is in the impugned judgment in Gayatri Balaswamy, my lord, the lead matter. Justice Ramasubramanian, as he then was, my lord, says that the remedy cannot be worse than the malady. That's how he puts it. And that is, my lord, in my respectful submission, the issue your lordships are deciding today. Whether 34 is a limited right that therefore gives rise.
There is a way of interpreting 34(4).
Yes.
If we accept there is an implied power or subsumed power of a lesser relief,
Yes.
34(4) can be exercised where the court finds it difficult
Yes.
to exercise that power.
Yes.
Say in a case where documents are not produced
Correct.
or hearing is not granted and award is passed, or otherwise you find that it's not possible to segregate and divide, then in that event, the court can exercise that power.
Your lordship.
That's the argument in your favor.
Yes.
The other side can argue the other way around and says the entire power of modification is subsumed in subsection 4 to 34.
Yes.
But you can argue that this will not curtail the power of the court, where they can correct the correctable errors
Yes.
by the court itself.
Yes. But
Curable errors by the court itself.
I'm deeply obliged, because that was my next submission. The argument raised against us is that 34(4) contains the power to modify, and therefore when the Act expressly contains one method to do this, no other power can exist. That's
So
how
that's the argument against you.
Yes, that's the argument against us. Well, the power under 34(4) is very different from the power of modification that we are requesting your lordships to find that the court will exercise while entertaining an application for setting aside. May I, my lord, place one decision of this court, but first, my lord, may I just place 34(4). The submission is this, that perhaps 34(4) is being misconstrued as conferring a power on the arbitral tribunal to modify its award. The scope of 34(4), my lord, is only for a tribunal to cure its defects of reasoning, not to change the end decision of the award. But may I place 34(4) and then the decision in IPA clearing? 34(4), my lord, on receipt of an application under subsection 1, the court may, where it is appropriate and it is so requested by a party, adjourn the proceedings for a period of time determined by it in order to give the arbitral tribunal an opportunity to resume the arbitral proceedings or to take such other action as in the opinion of the arbitral tribunal will eliminate the grounds for setting aside the arbitral award. And now your lordship will have, my lord, IPA clearing, which is in volume 4, my lord, of the Learned Solicitor General's compilation. Volume 4, 2063. Yes. 2063. But my submission is that this is not a power that allows the court to revisit its award or modify it. That power, if we are right, Lord, lies with the court in certain narrow guardrails. But this is not an opportunity, my lord, for a court to, my lord, send the matter back to a tribunal to revisit its conclusions, to revisit its decision. Your lordship will get that, my lord? 2063, does my lord have?
Yes.
Yes. At 2072, my lord, the judgment discusses an earlier judgment in Dyna, para 34. Schemes of justice. In the judgment in Dyna Technologies versus Crompton Greaves, it was a case when there was no inquiry under 34(4) of the Act, and in the said case, this court held that the legislative intention behind 34(4) of the Act is to make the award enforceable after giving an opportunity to the tribunal to undo the curable defects. It was not a case of patent illegality of the award, but deficiency in the award due to lack of reasoning for a finding which was already recorded in the award. In the very same case, it was also clearly held that when there is complete perversity in the reasoning, then the same is a ground to challenge the award under 34(1) of the Act. And then if your lordship has para 38. In absence of any finding on point 1, as pleaded by the respondent, and further, it is their case that relevant material produced before the arbitrator to prove accord and satisfaction between the parties is not considered, and the same amounts to patent illegalities, such aspects are to be considered by the court itself. It cannot be said that it is a case where additional reasons are to be given or gaps in the reasoning in absence of a finding on point number 1, namely, whether the contract was illegally and abruptly terminated by the respondent. Further, section 34(4) of the Act itself makes it clear that it is the discretion vested with the court for remitting the matter to arbitral tribunal to give an opportunity to resume the proceedings or not. The words "where it is appropriate" itself indicate that it is the discretion to be exercised by the court to remit the matter when requested by a party. When application is filed under 34(4) of the Act, the same is to be considered keeping in mind the ground raised in the application under 34(1) of the Act by the party who has questioned the award of the arbitral tribunal, and the grounds raised in the application filed under 34(4) of the Act. Merely because an application is filed under 34(4) of the Act by a party, it is not always obligatory on the part of the court to remit the matter to the arbitral tribunal. The discretionary power conferred under 34(4) of the Act is to be exercised where there is an inadequate reasoning or to fill up the gaps in the reasoning in support of the findings which are already recorded in the award. But I'm placing emphasis on this, my lord, to submit that the power under 34(4), if the court exercises in its discretion to remit the matter to the tribunal, which otherwise had become functus officio, is not to, my lord, reverse its findings or modify its findings. It is only to, my lord, give reasoning in support of its findings. And that is why, my lord, 34(4) operates in a different sphere than the modification power we are seeking, my lord, that the court has while hearing a setting aside application. And my lord, last paragraph, paragraph 41. Under the guise of additional reasons and filling up the gaps in the reasoning, no award can be remitted to the arbitrator where there are no findings on the contentious issues in the award. If there are...
We have seen that.
Yes. So, my lord, that's the submission, my lord, on 34(4).
It's not a power, it's not, certainly not a power of absolute rewriting or anything like that. It's certainly not also restricted, limited to the extent probably is indicated here. It depends upon the factual matrix of each case. It will depend upon the issue raised.
Yes.
Suppose some document has not been looked into as a result, or some document has been overlooked or wrongly quoted, or even the ex parte order has been passed, and whereas the notice was not served.
My lord, I'll make this submission, my lord, only as an officer of the court, my lord. I believe that would then be conferring some kind of a review power.
Anyway, we are not concerned primarily with 34.
But my lord, therefore the submission is limited only to saying that 34(4) is not a bar to find.
It's not a power of absolute review. There's no doubt
Yes.
about it. Review power, if conferred, is fine.
Yes.
But not absolute review.
Yes. It's not, my lord, an opportunity for the tribunal to again arrive at a different award. If, for example, my lord, evidence is not considered, then, my lord, that may perhaps be the end of the matter as far as that arbitral tribunal is concerned, subject only to your lordship's power or a court's power under 34 to modify or set aside the award. Because otherwise, my lord, we would be conferring on the arbitral tribunal a power to revisit its award, which I don't believe, my lord, the power is under section 34. But the limited submission I was making, my lord, was in response to the submission that since section 34(4) is there in the act, there is a power to modify in the arbitral tribunal, and therefore there is no power to modify in a court. I was therefore, my lord, distinguishing the power under 34(4) from, my lord, the power under the power that we are seeking, my lord, the court exercise.
Mr. Ritanrai, don't you think you're putting it in a very narrow perspective? The power under 34(4), if you go by the language, is not conditioned by so many limitations as you are putting on there.
Yes. My lord, if it were, I appreciate, my lord, this may be too narrow, but my lord, in my respectful submission, a power that allows the tribunal to revise its award.
Not
Maybe
review the order,
yes,
but it says eliminate the grounds for setting aside the arbitral
Yes.
award. So if the grounds are identified and thereafter the party makes an application,
yes.
is there any limit on the power of the arbitral tribunal to set aside those grounds which have been indicated, suppose in the order
As your lordship put it,
passed by the 34 court and highlighted in the application filed by the party?
yes.
Why can't the arbitral
As your lordship put it, my
tribunal
lord, if there are
set aside
certain
those
grounds that will address, my lord, the invalidity of the award, those grounds can be the matter of an application and then a reference to the arbitral tribunal. But in that application, the arbitral tribunal cannot review its earlier decision, is my respectful submission.
Okay.
And that power does not mean that the court cannot exercise the modification power that we are seeking to place and house in section 34.
Again, not to the extent of a review.
I'm sorry, what?
Even the power of modification there would not extend to the review of the award.
Yes, and it would not extend to a review of the award. Well, on my last submission before I...
Then what is the meaning of this power, Mr. Rai? Suppose a document is not put,
Yes,
and if the court wants it to send back to the arbitrator 34(4), and if the necessary consequence will be that we don't know what the arbitrator will do after seeing that,
yes,
after receiving the answer to that document.
yes.
So is it an empty power then?
Well, that's why the power is, in my respectful submission, quite curtailed.
Ultimately,
Because
you
your
say the
lordship,
award has to be intact.
yes, because your lordship will see that will then open an entire new chapter. If the arbitral tribunal
Right,
today-
probably, just like there be curable defects or issues or curable incongruities emerging in the award which the court
Not affecting the substratum.
Similarly, there can be, in fact, the power of curable to cure the defects with the arbitral tribunal may be larger. Maybe larger. They may be larger than what is with the court. Because the court can only do so when it's possible to segregate.
Yes.
But the court finds it's not possible to segregate, it can exercise that power. 43, if one has to go for fresh arbitration, it's almost a
it's a
de
clean slate.
novo,
It
it's
starts
a
over.
de novo.
No, your lordships are right. Well, the power of
And
modification.
then it will be virtually like a power of remand, and the power of remand which is exercised by the courts is also now we frown upon as long as the appellate court itself cannot decide the issue.
Your lordships are right, my lord, because in section 34, my lord, and I'll just come to that after one more submission, my lord, the guardrails are that the court will not review the case on its merits. So
That's fine.
within the confines. So therefore, it
No,
is
no.
narrower in that sense.
Correct.
It is narrower in that sense, my lord. But your lordship may also countenance, my lord, once an arbitral tribunal has rendered its award, to remit in that sense in 34(4), for it to re-examine certain evidence.
Can we
that-
now put a simple question? Can we now formulate? The court's power to cure the defects must be such for which they can segregate, divide, and cure the defects without affecting the substratum and the core of the award, without affecting the substantial substratum of the award, so as to segregate the invalid parts.
Yes.
In case of 34(4), where the court finds itself that will not be possible to do so, then they can remit the arbitrator cure the defects. The defects should be such which are which can result in the award being set aside on the grounds which are mentioned in subsection 1 and
Yeah.
2, sorry, subsection 2,
Yes, and
2
my
and
lord,
2A.
my submission is that this extends to all of 34, not just, my lord, the head of patent illegality. But,
Obviously, it will-
but my lord, my lord, I'm only placing this in 34.4. I ask myself, my lord, can an arbitral tribunal change the decretal part of the award? And in my respectful submission, my lord, that far it cannot extend.
Are you
Test
contradicting yourself?
that by this provision which says that the party making the application was not given a proper notice or was unable to present his case.
Yes,
In such a situation, if that party is given an opportunity by sending him back to the arbitral tribunal,
yes,
so the arbitral tribunal is now allowing this person to come forth with his case.
yes.
Will it not have the power to review what it said earlier?
My lord, that would be a ground then to set aside the award.
No. Even in fact, let's put it, the Inland Bank is very clear. The power of procedural review is inherent in every court or tribunal, whereas power of substantive review is not. And
Yes.
procedural review means where you have not served proper notice, proceeded ex parte, and made some mistake, which renders its procedurally wrong.
Yes. My lord, the way, my lord, your lordship may consider the example, my lord, that was just given to me, my lord. The party making the application in your lordship's example would then be making the argument that the applicant in the section 34 has not been given an opportunity of being heard and remand or send the matter to the tribunal. So, my lord, the party is not seeking on its own as to why the matter should be sent back to the tribunal. The party is making an application almost on behalf of the opposite party. And that may be, my lord, extending 34.4 too far. The party that comes in a 34, my lord, challenges the award.
This is the party who's making the application.
My lord, yes,
Go by what 34.2.3 says.
yes,
Party making the application was not given proper notice
yes,
or was otherwise unable to present his case.
yes,
The applicant who's complaining
yes,
that he wasn't allowed to present his case.
yes. That is,
So this provision would be available to the 34 court. All right, go back,
yes. It would
make
be
an
available, my
application
lord,
to
to
the arbitral tribunal.
yes,
Therefore, in such a situation, the award can always be reviewed.
yes.
Why not?
It would be available to the 34.4 court on an application or request by one of the parties. In your lordship's example, it would be the respondent who would be making that request.
Could be either party.
My lord, and that's what I'm saying, my lord, the respondent.
34 does not speak of only the successful party or the unsuccessful
But then
party.
your
It
lordship-
just says a party.
Yes.
So why should we limit it to one or the other?
My lord, my understanding, my lord, of 34.4.
A party may have succeeded partly in award, but it may be aggrieved by the part to the extent partly gone against it. A party normally will be filing an application in the 34.1 only if they aggrieved by the award,
Yes.
not if they're satisfied and happy
Yes.
with the award.
And there, my lord, ordinarily the other party would be seeking to support the award.
Correct.
But
But the other
those-
party may, look, please. As far as procedural review is concerned, we don't require any provision in the act.
Hmm.
That's a power which is now well established, is available across to all courts and tribunals without any specific power of review. For substantive review, there must be a power. This goes beyond substantive review. This
Yes.
certainly goes beyond substantive review.
Yes. Look,
What is being put to you is, suppose there are 5 claims awarded.
yes,
4 claims are all right. One claim, the party says, one party says is already settled. That document has been suppressed or not produced. Matter goes back.